this is Matthew Talbot. He is an elder law and estate planning attorney in Walnut Creek, California. And we are here today to talk about what an estate plan is. I started working at the firm last year, and prior to that, I had a vague notion of what an estate plan is, but I didn't really understand why we all need one. And I have since learned, so I feel we should share. So Matthew, can you tell us what an estate plan is?
Sure. An estate plan consists of a few documents, which we'll get into in just a moment. But the bottom line of these documents is they appoint an agent to make decisions on your behalf. So the principal is signing these documents to make it so that if they are maybe incapacitated or they've passed away and they can't make decisions themselves, then somebody else does it for them. This can be important because if you don't have these types of documents, then people have to fight it out in court, and it can become expensive, time-consuming, and emotionally just disastrous for everybody.
So it sounds like you're talking about the power of attorney and the advanced healthcare directive. Is that correct?
Well, those are two of the types of documents, yes. There's a couple others, and we can get into those in a moment. But in regards to the power of attorney and the healthcare directive, these documents are only valid during the principal's lifetime. And they, as I said, appoint agents either for medical or financial arenas. So the healthcare directive appoints an agent to make medical decisions on your behalf, either effective immediately or upon your incapacity. And these decisions can be as important as whether or not to pull the plug if you're in a persistent vegetative state or other sort of state. Durable power of attorney relates to financial decisions over non-trust assets. There's two types of assets, trust assets and non-trust assets. And to keep it very general, some types of assets, like a IRA or 401k, are never placed into a trust. So if you appoint an agent to make decisions about non-trust assets, it would relate to these types of accounts and perhaps other assets that are never placed into a trust.
Okay, and what are the other documents included in an estate plan?
Well, we have the healthcare directive and the power of attorney, like you brought up, but there's two other documents that are also very important, a trust and a will. So a trust is perhaps the most important document in an estate plan, and what it really does is separates ownership by making the trust own all the assets. And the key here is that in lieu of having to go to court to get someone in charge of the assets after somebody dies or becomes incapacitated, since the trust owns them, the death or incapacity of the initial owner is not as relevant. And all the successors have to do to take over is bring a copy of the trust, show that they were named as a successor to take over if the main principal is incapacitated or dead, and bam, you are the successor trustee, you're managing the assets for the beneficiaries. That is a lot easier than going to court and fighting it out in court. Much less time consuming also. So that's what the trust does at a sort of 5,000 foot level. And the will in this instance, they're generally called pour-over wills, and they take any assets that were maybe not placed into the trust, maybe inadvertently never titled into the trust, and distribute them to the trust to be distributed under the terms of the trust, which is important because that is the intent of the settlor, i.e. the person who put the trust together, and that is the most important thing that all of these documents are designed to prove after a time when maybe the settlor can't say their intent either due to their incapacity or their death. So those are the two key documents.
So it sounds like a trust is actually a separate legal entity that you're setting up to allow for the smooth transfer of assets upon your death. Now,
yes,
you've often heard of like trust funds, and you think there must be a lot of money there. So how much money, does the average person really need a trust?
Well, in the Bay Area, the average person does, because if you own more than $150,000 worth of assets and you die, and these are probatable assets, then you have to go through probate, which is an extremely lengthy and extremely expensive court process. The trust helps avoid court, but if you own one piece of property in the Bay Area, you're going to be above $150,000. And people's salaries in this region tend to be a little bit higher than in other parts of America and the world, so people are more likely to be above that $150,000 threshold. and it doesn't take mortgages into account. So if you buy $1 million property, but you have a $900,000 mortgage on there, it's viewed as $1 million property, even if it's really only worth $100,000, and you would still have to go through the probate process. So really almost anybody in the Bay Area, in this region, is probably going to need to do a will, trust, healthcare directive, and a power of attorney.
Great. Well, I think that's a good start to our introduction to estate planning, and we're going to make make some future videos and getting into a little more depth of what estate planning can do. Okay.